We are on.
Okay, great, thanks. Here we are, the second half of government operations on January 28th, Friday. And we are going to look now at 175, which in my mind, I keep referring to as 107 or 106, I don't remember, but it is the bill that would prohibit the release of identifying information of a juvenile upon initial arrest. That's all this, that's what this does. And Charity, I do apologize. I got your note late last night and just did not have a chance to call you. So just so that everybody knows, Charity is a product of Windham County. We're very proud of that. So with that, we will jump into this. And I do, so I think on the list today for people, I think we have Mike, Lisa, Marshall, Charity, and Jay. That's what I have on my list. Is that the order that we would like to take you in? First of all, does anybody have a particular time constraint and would like to go first? If so, we can do that. Otherwise, we will, and we hope to be done so that we can, jumping into our next one at 3:15. And again, we have Mike and Lisa with us for that also. So I tried to put these together so that the media could be with us in a block of time. So, yes, Mike.
Madam Chair, Lisa is trying to get out of another commitment and she might be a little bit late and might not get till the second one, just so you know. And
okay, so unless we have, and Charity, I apologize for kind of throwing this in your lap. We were working on this with David Scher. In fact, that's who it came from. The impetus for this bill came from him. So I do apologize for just kind of throwing it to you. We could have summoned him, but in his new role, I think he probably wouldn't have wanted to come. So, all right. So I think that the two, I thought there was somebody from DMV that was going to be here. Rats.
Madam Chair, John Federico wanted to be here, but he could not resolve his conflict.
Oh. He wanted to be here on this one?
Well, we invited him. Or was that?
Oh,
not
okay. No, I think that was my error. He was invited to the Agency of Public Safety. It would have, I don't know who DMV would have been here for this one, but okay, so that is my fault. But so I think that the two outstanding questions that we had around this were how this affects traffic violations. And we will hear from somebody from DMV. And I think perhaps if Jay can help me here, maybe it would be Mike Smith. I'm not sure, but I think maybe
he'd be good.
Yeah, I would agree. I think Mike would be good.
Yeah. And so that was one outstanding. And what we heard last year, I believe, is that traffic violations are not an arrest. So this doesn't impact a traffic violation. It's only when an arrest occurs that it is prohibited from releasing identifying information. And then the other outstanding question was around the section that referred back to other sections of the law that dealt with the definition of child, and I don't know if that got resolved. I will say that doing things this way This could have been resolved in about 4.5 minutes by Jay and Tucker and Eric and myself standing in the hallway. But because we're going back and forth with emails, it's just, I don't know if it's been resolved yet or not. So those were the two outstanding issues that we needed to resolve, as I understand it. And then I think Mike wanted to testify on it just in general, not necessarily on those two issues. Is that committee, is that where you remember that we were?
Yeah.
Okay. So I guess what I would do is ask, I do see Marshall here. So I think I'm going to start with, since we don't have anybody from DMV here, is start with that issue. And if Marshall, if you can talk to us about that, and if we're referring back to the right section of the law, and reminding us that we're not mixing this up with youthful offender status. So, so let's resolve that issue first, and then we can hear general comments on the bill itself. Does that make sense? Okay, great. So Jay?
I'm sorry, Madam Chair. So that is my question for purposes of the testimony. And so depending on what Marshall has to say, that will be very helpful. But if it doesn't, I may still have a question about meaning, just so you know. So I don't know if you want to just address me when, you take general comments, or if you want to continue that conversation, I'm happy to jump in.
Either one, yeah. Just jump in if you, okay. So Marshall?
Sure. Thank
Marshall,
you.
do you know everybody on the committee, right?
I believe I have met everyone, but I will introduce myself. I'm Marshall Paul. I'm the Chief Juvenile Defender and the Deputy Defender General. And I've appeared in front of this committee a few times. I'm not a regular here, but occasionally you touch on juvenile law, and then I come in. So I'm very happy to talk about this. This bill addresses an issue that I think is really important, which is just ensuring that we have consistency and predictability in the confidentiality of these records, because right now it's just a hodgepodge. Different law enforcement agencies interpret the laws differently and apply them differently, and it makes this very difficult for us as juvenile attorneys to counsel our clients, to talk to our clients' families, to let our clients know what to expect. Like, should you expect this is going to be public? Should you expect this is going to be confidential? And we often have to tell our clients, you have to be prepared for anything, because it's really up to some individual law enforcement agency's interpretation of a very confusing law. So we're happy to see this get addressed. And as to this question of the definition of child, we believe that the definition of child in this bill, which refers to the definition that's in Title 33 in Chapter 51, which that's the chapters that deal with all juvenile justice and child welfare issues. And I actually think that's important to bring into the conversation, is that child welfare is at issue in this also. Police do respond to the scene of child welfare incidents where children are victims, not necessarily of crimes, but of a civil proceeding for the protection of that child. And that is encapsulated within this definition of child here. So this would apply not only to children who are accused of being essentially the juvenile equivalent of a criminal defendant, because they are alleged to have committed an act that would be a violation of the law, but also children who don't necessarily fall into the protection for victims of crime, because child welfare violations are not necessarily crimes. It's a civil proceeding, but who get that protection because they do fall within this definition of child. And I also like the reference to the definition of child that's in Chapter 51 of Title 33, because it sort of backstops the overall definition here. I mean, the definition that we're using is children who are subject to the jurisdiction of the juvenile court. And the definition of child only applies to children who are subject to the jurisdiction of the juvenile court. So when it says child here, because it only means children that fall within the definition of child in Title 51. It only applies to children who are subject of a proceeding under one of the chapters of the Juvenile Justice Proceedings Act, or the Juvenile Proceedings Act, the JPA. So, like I say, we support this in general, and we support this particular definition because we think it has a very important narrowing effect on the statute, and it ensures that the statute is not so broad that it's referring to just any child anywhere or any child under a particular age. And it narrows it so that it's saying specifically these children who are the subject of the jurisdiction of the juvenile court in a juvenile case, those are the children whose identifying information is protected by this law, not other children. We think that's a good thing. We think it keeps the law narrow, and we think it keeps it predictable. And we think it makes it into something that is very easy to be applied consistently all around the state, so we don't end up in the situation we're in now where, it's applied differently everywhere you go.
So I do have a question about that. So
Okay.
this would apply to the initial arrest of any child who could be under the jurisdiction of family court, which means any child who is arrested or a victim who is under the age of what?
So the definition there's a multi-part definition, and it depends on which part of the definition you're asking about. So it can be under the age of 18 and is going to be petitioned to be a child in need of supervision. That means a neglected or abused child, or a child who is truant, or a child who's beyond the control of their parents.
Mhm.
It can also mean a child who's under the age of 22 and is subject to the jurisdiction of the court as a youthful offender. That's in definition number 3, or not 3, C. I get my 3s and my C's confused. And let's see if it can apply to anyone else. No, it's between the ages of 10 and 22 and subject to the jurisdiction as either a delinquent or a youthful offender, or under the age of 18 and subject to the jurisdiction as a child in need of supervision.
And I think that's where the complication came in, because the governor's office was concerned that it applied now to every child, everybody under the age of 22. And I think our intent was to apply it to juveniles as we raised the age of juvenile from 18 to 19, and from 19 to 20, and from 20 to 21, but not necessarily to that right now a 22-year-old would be, they would be eligible for youthful offender status, but that they would not, that those names would be released. It was only the juveniles that were under the, I keep saying raise the age because I don't know what else to call it, but
Yeah, I thought it was 19 that we were talking about.
no, we're talking,
Low.
In looking at this actually more closely, I'm noticing that there's actually, the way this is written is a little different than I first understood it. As you were explaining it, I was able to see, so it refers to 2 different subsections of, or a particular subsection of 5102, which is 2C, which includes everyone from age 10 to 22, but then limited to the ages enumerated in 5103 C2A, which limits it to, right, to 19. So I agree, that would do exactly what you said. It would limit it to people under the age of 19.
Right.
but, and then as raise the age in 2023,
Yes,
when we have the new raise the age up to, then that statute will change. And
Yes.
so then this would apply to them.
Yes.
That's what I thought. That was our intent, was not to apply it right now to people beyond the age of 19. But as the raise the age went up, it would continue to refer to that, because in the original bill, we had an age in there. And
Right.
that didn't make any sense, because then we'd have to go back and change it if the raise the age went through. Okay, that helps. That is helpful. Jay, is that helpful to you?
Okay, so sort of, I guess. I mean, I'm glad that Marshall had the same problem with it that I initially did. And then you have to look at the conjoinder of the and. But then isn't the next provision, it's 33 VSA 5103 C2A, correct?
Yeah.
And that says, just on its own, so I guess my first point I would like to make is records officers and agency staff, and really for the guidance of, say, troopers in the field, have got to understand what this says. So that's one just sort of one point I'd like to make. The other is, so when you read this part, which I understand the intent is to be narrowing, and I appreciate that, it reads, jurisdiction over a child with a delinquency may be extended until 6 months beyond the child's 19th birthday if the child was 16 or 17 of age when he or she committed the offense, or 20th birthday if the child was 18 years of age when he or she committed the offense. And then that will go up to, 21st birthday if they're 19 when they committed the offense. So I get the concept is incorporate the raise the age, but my question is, to me, that is still not clear. When you're a VSP field officer doing a media report, I just arrested somebody who's 19. Where in there does it tell me what to do about a 19-year-old? Or somebody up to 19 or somebody up to 20? So I guess my real point is, I think what we really need is simplicity. And that's why I like a number. And I think that what happened last time was that it flagged the raise the age issue, which had going on at the same time a number of associated programmatic issues. So it gave us the opportunity to take a step back and take a look at raise the age. And I do appreciate, and I cannot say strongly enough, offer strongly enough my thanks to Chair White and Senator Sears and the Senate Judiciary Committee for taking this up in the summer and working on it all the way through the fall and really expediting its passage through the Senate in, by January 18th, which is kind of extraordinary. So I really appreciate that. And that's why I would like to work with you on this. It's just that I feel like using this particular cross-reference and the way that it's structured with sort of the two-tiered legal analysis is very complicating. And I'm thinking, if you had to use a two-tiered analysis, couldn't you at least go to 5201D, which says 19 and goes to 20? Unless it's changed, and that's the issue in raise the age, is the delay, July 1, 2022, whether to delay the age, raising the age to 20, given the issues we know with the program at this point. So I think that to the extent we want to tie them, that makes sense. If this doesn't change, obviously it would go up just along with the program and the issues. But assuming that the House takes action, which we can't really assume until we get the bill, it's just hard to tell what that number should be. So to my mind, I'd say 19 covers the current law, and that any increase subsequently is handled at the same time as the committees take a look at raise the age when 20 is expected to kick in, potentially in 2024.
Yeah. Okay, so it'd be like setting a $10 limit and saying, but it's going to change with CPI.
Yeah, something like that, I guess. I mean, the idea would be if you tied it to D and the House takes action consistent with what you did, not D, 5201D, and the House takes action consistent with what the Senate did, then that would travel together consistent with your intent.
Yeah.
But so that's my real point is I think you need clarity, and I'm not completely sure that this cross-reference to 33 VSA 5103 C2A does it.
Okay, so,
And I would agree with that. I actually was not, and I just to clarify what I've said before, I actually didn't quite understand that the committee was aiming to use 19 and to try to find a statutory provision that would really encapsulate that. I don't think that 5103 C2A does that, because that really is a provision about the extension of jurisdiction. It is sort of a confusing concept, but there's jurisdiction to enter juvenile court and then supervision jurisdiction. And really, we shouldn't be looking at supervision jurisdiction. We should be looking at filing jurisdiction, which I would agree with Attorney Johnson that 5102 or 5201 is the appropriate place to be identifying there. If we're looking for that age of filing jurisdiction, that's the right approach.
okay,
And
so,
I-
yeah, so
that's
the
the point.
intent of the committee here was to say that cases that would end up going to family court, those are the ones where the initial arrest identifying information should not be released. Because if it goes to family court, it's confidential, but it's already out there in the public. So that was the intent. So might we ask Jay and Marshall and Tucker to redraft this so that it is clear and does exactly what we wanted to do? Because this is kind of what was come up with, I think, between Tucker and Eric. But we need to make sure that it really does it and that it's clear, like Jay said, for the officers in the field to know what they're doing. So does that make any sense to people?
Yes.
Okay.
Good idea.
I don't think we want our live transcription enabled.
No,
We,
we only wanted it for that little bit of our meeting.
right. Gail, can you take that off?
Madam Chair, it's not enabled for the meeting on my screen. I think it might be your personal device. Is anybody else seeing it?
I see it. Mine says live transcription, closed captioning has been enabled.
That
Okay.
might be an old notice, because
Right, is there a little X, is there a little X next to that?
Yeah,
Touch the little X and it'll go away.
you are magic, Anthony.
But we do have a new participant who is requesting that it be enabled for the meeting.
A
Undo the X.
participant in this, one of our
Our meeting
participants?
right now?
Yeah, one of the people who's part of this Zoom meeting.
Okay. All right.
That's me. I'm only doing it on accident. I have no idea what it even is,
Well,
much
don't,
less that I would be doing it.
the problem, what it means is that underneath on the YouTube, it'll transcribe what you're saying, but it transcribes it in such a bad way that and the only example I can give that's really short is when we were talking about pensions, and Mike Pichek was talking about something, and I don't remember what he was talking about, but he certainly was not talking about bathroom designs, which is what came up on the screen. So we do not use the closed captioning because of that, unless it's requested by somebody as one of our participants. So
And
thank
it's
you.
done automatically within 24 hours on YouTube anyway.
But even those transcriptions are not very
They're
accurate.
not perfect, but they're much better than the live.
Yes, but we don't use it. So, okay, thank you. That cleared that up for me. Thank you. We also don't use chat, just so everybody knows. And I failed to say that at the beginning. I try to say that at the beginning of every meeting, and the committee knows it well, but okay. So does that make sense, committee, to have Jay and Marshall and Tucker work on, and Charity, if you have any input into that also?
Makes sense.
Yes,
Yeah.
Tucker.
I would just like to raise one other question that I will be raising with that group then, which is because of the way the first definition works, the definition of child, because it's subsection C, 2C, it basically refers to an individual who's been alleged to have committed or has committed an act of delinquency after becoming 10 and prior to becoming 22. And a delinquent act is defined as all crimes plus underage, misrepresentation for purposes of buying alcohol or possessing alcohol. But it has certain carve outs for snowmobile offenses, motorboat offenses, and certain felony motor vehicle offenses. And I'm just not sure if you intended that either. So that's my only other question that I'll be raising with that group.
Okay,
And Madam Chair,
yes.
I would suggest we wait and have that conversation with the DMV crowd.
No,
Isn't that, aren't the, or did we mean, I thought that's why you wanted to include the DMV crowd in this conversation.
not because of snowmobile accidents or anything like this. It was motor vehicle accidents are
Okay.
required to be public information. And so those names get released. This is on initial arrest. That's what this is about. If
Right.
somebody has a snowmobile accident, and so that we do need to make sure that we respond to that. If they have a snowmobile accident, they're not arrested, then there's
Right.
not an issue. It's upon initial arrest. That's what this bill says.
Right.
So, okay, so those two issues we can have worked out. Is that I, if at all possible, would like to send this bill out of our committee by next Wednesday, if it's possible for you to work on it by then. Tucker?
Thank you, Chair White. I just want to clarify as this group is moving forward. Jay had put forward two proposals for you. The first that she brought up was explicitly stating the age like you did in S107, but leaving out the portion where it automatically was raised by a date certain. In that case, it was this July 2022. That's option A. Going back to that language and saying 19 years old, and then leaving it up to the other committees of jurisdiction in the future to raise that age as they do other raise the age work. The second option appears to be to find a better and more clear definition, potentially 5201D, to determine the age of the person and have it, as Senator Clarkson put a few weeks ago, ride the wave of the work you're doing with raise the age.
Mhm.
So which would you like? Would you like us to work on the explicit age version or the link it to the Title 33 statutes version?
I guess Senator Clarkson, did you have a preference?
No, I'd like to link it to, so we don't have to keep revising statute. I think let's link it to ride the wave. I mean, it's now going to hopefully be in statute that it's 19 and in 23 it'll be raised. And so as it raises, so does the age. I mean, as it advances through time, so does the age. Well, like all age advances through time, doesn't it? So I would rather be less explicit and refer to our work in the statute already about raising the age.
But I will leave it to the,
Yeah, they're going to come back to us with a solution to this. I think they have a sense of what we want, Madam Chair.
yes, that is exactly what I was meant to say. Thank you. Okay, so I will leave it to we'll leave it to the three of you and Charity, if you want to have input into that from the AG's office perspective.
Thank you.
Thanks. So then the other issue was the motor vehicle, and I think there isn't an issue there, but we will hear from, and we'll contact Mike to come with it. I think Mike Smith is the most appropriate person, but we'll contact him and Commissioner Manola just in case she has somebody else that she would prefer to testify. Okay, does that answer those two issues? Okay, now, does anybody want to weigh in? Thank you, Marshall. Thank you, Jay. Thank you, Charity. And you're certainly welcome to stay and weigh in on the now kind of the general concept of the bill and what it does and why we want to do it or why we don't want to do it. So with that, I think I will jump to Mike Donahue.
Thank you, Madam Chair. Yeah, we do have concerns about the bill, and I'll jump around here a little bit. One thing you had mentioned was this only pertains to the initial arrest. Well, unfortunately, for more than a year now, police, including the Vermont State Police, have not interpreted that, and they're withholding public records from the public on simple cases that have no criminal activity, but because the person is, whatever, 17, 18, 19, 20, 21, whatever, they think that they are not allowed to give out the name of a driver in a motor vehicle accident, even though there's been no determination that there was anything done wrong with the crash, that, and conceivably maybe the other driver crashed into this 18-year-old. And so the 18-year-old is not at fault, not facing criminal court action or anything. And yet the Vermont State Police have a policy. It's the gag order that Commissioner Sherling imposed that more than a year ago. That's still in place, the one that he asked the Attorney General for a legal opinion and could never get one from him, even despite prodding from the governor's office and elsewhere that they were looking for a prompt answer. So we're still, and as an example, there was a fatal the other day in Thetford, and the driver was, I believe, 17 or 18, and it was a pedestrian that was killed. There is no indication that there's any arrest or whether the pedestrian or the driver did anything wrong. Everybody's been looking for the name of the driver, and the Thetford police are using the state police gag order as their excuse not to give out the name of the driver, even though there's been no indication of any criminal wrongdoing. So I know at some point, I believe some of the TV stations will be in. I know they've had concerns. I know the Valley News had concerns, Journal Opinion, several newspapers are concerned that information is not being provided. And again, I know you're saying under initial arrest, but there's been no arrest. All we're looking for is the information that is in the public accident report that the DMV will actually have on file, usually within 30 days of a crash. So that is one of our concerns. The other concern, one of the other concerns is, I think on page 2 of the bill, it makes reference that public agencies may disclose ID information relating to the initial arrest in order to protect it says the health and safety of any person. And I think we're trying to figure out what that means. And I think last year, I think maybe in the House and elsewhere, that leaves it wide open to interpretation. So the Rutland City Police or the Fairhaven Police, if they have somebody arrested for DWI at the age of 17, 18, 19, may want the public to know that a 19-year-old has been arrested for DWI, so that parents may not want people riding with that person. So Rutland City and Fairhaven may say, we're giving it out, but Rutland Town may not. So there's going to be some inconsistency, same with Montpelier or Barry, whatever. If you're leaving it up to them to, in order to protect the health and safety of any person, then they can give out that information as far as I'm concerned. The other thing that we're concerned about is that there does seem to be putting the information only in the court system. I know I've talked with troopers and others that if they're on the side of the road on a Friday night, that they aren't going to be able to get access to that until the courts reopen on a Monday, or, like last couple of weeks ago, Martin Luther King wouldn't be open till Tuesday. They need information when they're on the side of the road dealing with a case. So the fact that it's going to be in a court system that is a 8 to 4 operation, and as you know, is not being well run these days and has some issues, just seems not to be a good place to be putting where the records are. And I think we would support having a backup system whereby police or some other system would have access to those records, and not just during business hours. We remain concerned about the definition of a child. We don't think that people that are 19, 20, 21 are really a child. They're out there fighting wars and doing other things. And we would object to that issue. This case does, a lot of this goes back to that fatal in Charlotte, where the 16-year-old girl killed 2 people crossing the center line, and essentially there was an effort to hide the name. It became public, and the state found out that the only thing that happened there was she got a $220 ticket. So I think the public needs to have, and I realize youthful offender and this law sort of overlap, and that's why we asked for, way back, a clearing up of what the real public record is and how to keep the public informed in their communities. So those are just some of our concerns. You heard some of those last year. They haven't changed, obviously. And we're glad to answer any questions you might have.
So I have a couple to start off with, and I'm sure the committee has some also, but my first one is just a kind of a technical question. It's not a philosophical one at all, but the trooper on the side of the road that stops someone, what records are you referring to that are in the court that they can't get access to? What this says is that it has nothing to do with the trooper having access to records. What this says is that if once a case is assigned to either criminal court or juvenile court, they become the custodian of the record. So if you wanted to find out who that 17-year-old was that was arrested, if it went to criminal court, you would go to criminal court and ask for that record if that's where it was assigned. If it went to juvenile court or family court, you wouldn't go, you would go there, but they would tell you it's confidential. That's all it says. This has nothing to do with the trooper on the side of the road. So I don't understand that.
Right.
So if there is a trooper pulls somebody over for being an impaired driver, and there's some reference to apparently this is his second impaired driving case, and they're trying to find out what happened to the first case, and all those records are in the court. They're not at the barracks or wherever where the trooper would have access to figure out whether in fact he ever was convicted or what happened on the first DWI case. From what you're saying, all records from that first case would be held by the courts.
They would be the custodian of it. I do not, Tucker, because I think this doesn't affect the ability of the trooper to get that information. It affects your ability to get that information, not the trooper.
Okay,
Is
I'm just
Tucker, am I
talking,
right?
I'm just talking about what the police have told me, that they think that they would not be able to under what they're
Yeah.
reading in your law, in your
Right,
bill.
but they're wrong. So,
Okay.
Tucker,
To be clear, the part of the bill that talks about custodianship is within the Public Records Act. If a member of the public is requesting these records, at the time it is referred to a court, they will be sent to the court to find the records. This will not prevent a law enforcement agency from accessing their own records. It will prevent that law enforcement agency, upon a public records request, from releasing identifying information to the public. The law enforcement officer at the side of the road will be able to access law enforcement records.
yes. So that takes care of that concern. And I just, I understand this. I guess I don't understand what is the public's interest in knowing who the driver was. It will be public in the DMV records, but I don't understand why the public has an interest in knowing that my neighbor was the driver of that car. How does that, I guess I don't understand. I know that this is a question of the public wanting to know, but sometimes the public wanting to know is not sufficient reason to release something just because they want to know. So I guess I don't understand the issue around and we're only talking about initial arrest, and then we're talking about cases that go to family court. Cases that go to criminal court will end up being public record. So. So can you answer that, Mike?
Yeah, I'm sorry, somebody was talking in the background. I wasn't
Yeah.
sure who was. Well, first of all, a couple of thoughts. I mean, names make news. That's why people want
Right.
to know who it is. That's just the old basis of news since the beginning of time. That,
Right.
you know, it's a non-news that when you hide the name, that nobody knows who it is. So number two, the Vermont Public Records Law, as you probably well know, says why somebody wants a record is irrelevant. You know, it doesn't matter why it's wanted. If it's something is public, it's public. So
Right.
I guess, you know, we're asking, and I'm not sure why instead of having the information immediately available that we have for forever, I guess, but at least in my 50 years, we've always had at an accident report that the information was available, you know, within hours. Why suddenly does the media and the public have to wait 30 days now to get the name of that driver that was on a public highway, that was publicly licensed, that public safety agencies responded and invested taxpayers' money? Why you're trying to hide the name? And again, we're not saying that there's any charges coming out of this accident. All we're saying from day one, we've maintained, you know, the accident report is a neutral document. What the state's attorney in Windsor County or in Chittenden County or Washington County does with it after, that's their job. They can figure out what to do with it.
I understand that, and I understand that names sell news. So I understand why there's that interest, but we're not trying to hide anything. I think the impetus here is to protect the youth that has, in some cases, a devastating accident, makes a huge mistake, And once their name is out there, their lives are impacted forever, because not only is it just out there in the Rutland Herald or wherever, but people pick that up and it's online forever and ever and ever. And if it goes to criminal court, that's one thing that is public. But if it goes to family court where it's confidential, and we don't know, for example, that the only thing that this girl got was a $250 ticket. She may have been sent to diversion. She may have done all of those other things in family court. So we don't know that for a fact. And yet now everybody associates her with being this awful person who killed 2 people. And that's the point of this, is not to hide anything, but to try to make sure that people who make, and sometimes it's very, very serious mistakes. Sometimes it's just shoplifting, but their lives are going to be impacted. And that's the point of this, not to try to hide anything. So I will get off my soapbox now, because yeah.
It's an important.
But you are hiding it. That's the bottom line, I guess.
No, we're
You are
not.
hiding it.
We're protecting young people.
But
I don't think
Mike,
we're hiding anything.
Mike, you could say the same thing about any proceeding that goes on in family court. We are hiding that also because it's confidential. We are hiding things that happen in family court around Chin's.
I think you're talking about juvenile court, Jeanette. Family court is.
No, the 19 and
It's
under.
family court. It goes to family or criminal. Those are the 2 courts. Am I wrong?
I think it's the same.
There's a family
Juvenile
court,
court is family court.
there's
Yeah.
a family court, and then there's a juvenile division of the
Yeah.
family.
Right,
But
right.
I
That's
just
all
like
under the
a lot of
umbrella.
family court is public, so I just
No, things in family court are not
No,
public.
they're not.
Some
A
things
lot of-
are.
a lot of family court is public. I used to work in family court. That's like divorce and child support and things like that. Those are public.
The whole domestic docket, RFAs, divorces, parentage, that's all public.
Yeah, but
I
the
just don't wanna
point
conflate.
here is that the record goes to the family court. They have their own rules about what is public and what isn't public. So if it goes to family court and it falls under their juvenile division, they make that decision. The public agency that arrested them does not. That's the point here. It goes, I mean, there are some things in family court that are confidential. Not everything in family court is public. The way I understand it.
I understand, and I think I've said this before. You know, the newspapers aren't necessarily concerned about the people that are shoplifting and they're 18 years old or 19 years old and they're a college kid and they do something stupid and steal a beer out of the grocery store or something like that. You know, I don't even think papers report those, to be honest with you. But you know, it's the big ones.
And the big ones will probably go to criminal court if they're that big.
I
Anyway,
don't agree, Mike.
Well, no, we're seeing
Okay.
a lot of these 17, 18-year-olds. The guy who opened fire in the University Mall, he, you know, well, he went to adult court and it was immediately a motion to move it to family court. And it turned out that when they denied it, but he had already put a gun in somebody else's face during a robbery 2 months earlier. So, you know, there is a move to get these all into juvenile court.
Okay. Okay. Anybody else have any questions or comments or concerns? Charity, did you have anything to weigh in on here that we didn't hear from you about?
No, nope. I think everything that I was going to touch on has been covered, and I'll look forward to convening with others to talk about the definition of child. Thanks.
Yeah. Thank you.
Can
Yeah.
Marshall, I think I asked this question last year, but I'd just like to remember, and maybe there's updated information on the kinds of disparities about who's tried as in criminal court versus who's kicked back down to juvenile court. That I still worry that some people are given the benefit of the doubt, or they have better legal representation to be protected more in the legal system, and others won't benefit from this at all.
I am not as worried about that. And the reason is that what we've seen, I think what you're talking about, and correct me if I'm misinterpreting your question, is in situations where a case could go to juvenile court or could remain in the criminal court, is there a disparity in who's going to criminal versus who's staying in juvenile? And I would say that the answer to that is, for the most part, no, but that's entirely anecdotal. That's not based on statistics. We haven't seen statistics yet on this because honestly, we just haven't had this system in place for long enough yet to really be able to draw any conclusions from statistics. But I would say that what we've seen is that judges are actually making those decisions pretty carefully. We see about 50% of the petitions that are filed are either denied or withdrawn. And those are for a variety of different reasons. And it doesn't seem to be any particular type of person who is, or type of representation that's getting different results. It seems to be pretty, even across the board. So I would say that overall, anecdotally, my impression is that things are working pretty well. And it's not disparity that's driving who gets into juvenile court and who doesn't. It's more the circumstances of each particular case. I do think that there's some data from, I think it was not the most recent batch of data that was reported from DCF to the Office of Juvenile Justice and Delinquency Prevention, but the second most recent batch did identify a large disparity in juveniles who are tried as adults, which is sort of the flip side of your question. It's not, who's, sort of on that cusp and is getting down into juvenile court, but who's in juvenile court is instead being brought up to criminal court. That there seemed to be definitely a very dramatic racial disparity there. So that's, I think, does that answer your question?
Yeah, and there's no way to protect those folks and treat them like young people in this instance. They're in criminal court now.
Right, there would be no way to really differentiate them from anyone else in criminal court.
But that doesn't impact this bill necessarily, because this is only an initial arrest. That's an issue that we have to work on separately. And I will say, and I can see if I can get forwarded to committee members if there's an interest. In judiciary, we had a report from Council of State Governments on the racial disparities within our court system. It was really, really interesting. So if committee members would like, I will have that. It was a presentation with a lot of, what do you call those, PowerPoint pages. And I will have that sent to committee members if you'd like, because it was pretty interesting. It was talking about some of the stuff that Marshall was talking about.
So if it's on your webpage, we can find it there. Was it just this year?
Yeah, it was about a week and a half ago.
So we could probably find it on your webpage.
Yeah. Yep. Are there any?
Marshall, if you could also send that racial disparity.
Yeah. That would be great.
I will. Yeah,
Okay.
I will.
Is it okay? I can send that to you, Chair White, and will that work?
Or Gail. Gail.
Or Gail. Yes, I'll send it to Gail. Thank
Yeah,
you.
send it to Gail and that would, yeah. Thank you. Anybody else want to weigh in on this bill? And I do apologize for getting so heated under the collar, if that's what you call it there. This is something I've been concerned about for a long time. So my apologies for that.
I think you've said it well, Madam Chair. I think you've
Jay?
done a nice job with it.
I've always thought you were even tempered, so don't worry.
Jay?
Yes, I would say if that was hot under the collar, you're that it's something to be proud of. The only thing I would like to add is just a little clarity on the public safety policy, which we are supporting at this time as it relates to juveniles. But basically, they changed their policy. They made their interpretation more strict with reliance on the juvenile law, even though there is a gap there. So I think that they determined that their media reports would be part of the record, and they decided that. So what they will do is withhold if that person would otherwise be cited into juvenile court. They withhold the information until such time as that determination is made. That's the current policy.
So under this, they wouldn't release that information at any point because the court would become the custodian of the. So people, instead of going to DPS or the sheriff's office and asking for the record, they would go to the court, who is the custodian. That's the only difference here.
Yeah. So it should be that if they don't get cited into court at all, or if they get cited into criminal court, those records should be public at that point.
But I think our concern, Madam Chair, is there has not been, as you say, an initial arrest. That's the phrase that keeps being used, upon initial arrest. We're in limbo between the time the kid who's drunk crashes into a car and kills somebody or seriously injures them, and the state police are doing the investigation, and they ship it off to the state's attorney, and a month, 3 months, 5 months down the road, they make a decision. Okay, we're going to take them to family court or adult court or something like that. There's been no arrest until that time, and our contention is that should be public record and released. There's been no arrest.
But the motor vehicle information is, but as you say, it's not available for a number of days, but it is public. So if it takes them 3 months to make the arrest, the motor vehicle information would be available before that. And again, I don't know how many of the general public knows they can go to the DMV. They rely on newspapers to provide the news. And you can go to DMV.
True.
Anything else? I apologize for kind of monopolizing the conversation, but
You've done a great job.
So I think that then we will try to take this up again, not next week, but did I say, oh, no, I'm looking at my little chart here, hoping it serves me well. This is 175. No. Yeah, this is 175.
I thought you said.
Yeah.
But did I ask you to have this done by next Wednesday? It's the next Wednesday, the 9th, that I have it on I don't have it on for next week at all.
Oh,
so
that gives them an extra week, so they're thrilled.
Yeah. Okay. Sorry about that. Okay. So committee, should we jump to our other media issue?
Yeah. And then we're amazingly on time.
Okay.
Thank you, Laura.
Thank you. Thanks for coming. Bye.
Thanks, Jay.
Thank you. Bye-bye.
Bye, Charity. Okay, committee, now we are looking at 174, which is another media issue. And I have on my list of people here, I have Ann, Jordan, Chris Winters, and Gwen and Mike. Goodness sakes, Mike, you like us today.
And
hey,
maybe
I can't turn you down when you get 2 invites from you. I said,
gosh, it's news. Maybe someone should print it.
And I don't think I'll get hot under the collar right now. So
did Mike, did you say Lisa?
I don't see a caller.
Mike, did you say Lisa also wanted to speak to this because she was going to try and come at 3:15?
Yeah, I think she She was trying to, and we had tried to get a couple other people like Steve Pappas from the Times-Argus, Rutland Herald, but we were told that
She's
we'll
here
get
now.
him next time or something like that. So
Yeah, and I do
and I
want to
was
say,
told, excuse me, I was just told, I'm not necessarily here to testify. Gail just said more maybe to answer questions or if there was questions that came up, but I know the Vermont Standard also plans to try to testify the next time around. And there was one or two others. So I realized
Okay.
you only had an hour today. So
yeah.
Lisa's here, but she wrote that she is fine with the written testimony she submitted. She wants to say.
Oh, okay. So I think what we'll do is first go to Chris because there were some questions and this might clarify some of the stuff no, the first thing I'm going to do is some of you have not, Jordan, I'm particularly talking to you here. Who do I see? You don't know our committee members. So I'm going to have us start by introducing ourselves to you. I'm Jeanette White. I'm one of the reformer readers from I represent Windham County. Thank you.
I know your name and thank you so much for the introduction.
I'm Anthony Polina, I represent Washington County.
Brian Collmore representing the Rutland County District.
Allison Clarkson representing Windsor County District.
Aisha Ram Hinsdale, Chittenden County.
And my live transcript message came on again. So
Yeah, but I hit the little
I
exit
got-
go away.
I got feedback from someone that they did not see it on the YouTube feed.
okay, great. Thank you. So I think that the first thing we'll do is last time some questions came up about the posting of information and from the statewide from the Secretary of State's office, because the Secretary of State's office handles all of that. So what I'm going to do first, I think, is go to Chris, because he can answer some of those questions, which might answer some of the questions that some of you might have. So Chris, would you like to join us?
Sure. Thank you, Madam Chair. It's a special treat when I get to be with Senator White first thing in the morning and at end of the day. I don't usually hit those two committees in one day. Chris Winters, Deputy Secretary of State, and I did get to listen to some of the testimony last time around on this bill and understand there are some questions about what the Secretary of State's office does. With your permission, Madam Chair, maybe I'll just give a quick summary of what we do as far as rules, publications, and constitutional amendments. Those are the two things that we tackle in the Secretary of State's office. Just see here. So we publish many notices in newspapers across the state in the course of our statutory duties. And here are just a few. The Administrative Procedures Act. Some of you may be familiar with rulemaking, and the Vermont APA, which was first adopted way back in the 60s and is the process by which administrative rules get out and are adopted by state agencies. So that's one of those functions where you want all Vermonters to know and to be aware that an agency is making rules based on laws that you've passed as a legislature and that the governor has signed. And these rules have the effect of law. So it's really important that everybody knows what's going on, because DMV might be putting something in place, or Fish and Wildlife, or ANR. And Vermonters need to know what those are and have an opportunity to comment on those. So we have a filing system that you're probably aware of, and forms and a certain process that folks have to go through. And then we have the publication of notice for rulemaking, which comes from Title III. So we publish online notice of rulemaking. That's required. And we do have a website within a piece of our website within the Secretary of State's website, the Vermont State Archives and Records Administration section of that. We post a notice of every single rule that is proposed. And then there's a newspaper publication of that as well. So we're required to publish that in newspapers of record. And so, and newspapers of general circulation in the state. So a lot of when we hear about legal notices and we hear about what towns are doing and trying to publish those legal notices, they'll look to this. It's really a rulemaking process. It's what we do for rulemaking, but they'll look to the Secretary of State's office for guidance on what's a newspaper of record. And that's a list that we developed some time ago to try to get as broad a coverage as possible, get notice out to as many people as possible across the state, covering the entire state. So it's a fairly long list of newspapers, and I'll read them quickly here. It's the Burlington Free Press, the Rutland Herald, the Caledonian Record, the Times Argus, Vermont Lawyer, Valley News, Addison Independent, Bennington Banner, Brattleboro Reformer, the Chronicle, Newport Daily Express, News and Citizen, St. Albans Messenger, White River Valley Herald, also known as the Herald of Randolph, and the Islander. And I wasn't involved in making any of those, decisions. I think that those decisions were made a long time ago as to which papers were of, adequate to serve the purpose of notice across the state and to fulfill the statutory requirements of 3 VSA 839. There's a cost to that, of course, and you may have heard some of that already, but we charge agencies $2,200 to publish a notice across the state in all of those different papers for the purpose of rulemaking. So that's one way in which we use newspapers for publication, and another is for amending the Constitution. We've got a couple of those, Prop 2 and Prop 5, which we're dealing with right now. There's an interim publication notice. So in between biennium and then after, if in this second biennium, if the Prop 2 and Prop 5 are passed, we will do a publication again across the state to let Vermonters know there's a proposed amendment to the Constitution, kind of a big deal. So we want to get notice out to as many people as possible. And again, we'll use those newspapers of record to do that. And we did do that after in between the first two biennium to put that notice out there. So I guess I would just conclude by saying that the Secretary of State's office isn't here to, say print publication is better or online publication is better. It's about reaching the greatest number of people possible. And when we've been asked about this, we think the statute is there was room for interpretation there. And we've said, really, it should be up to the town to take a look at that and decide whether online or newspaper hard copy is better for the notice that they're trying to get out. And we really don't have any idea what the reach is of the local papers or of the local websites that might be online papers. But what we do know is the intent is to try to reach as many people as possible. And I know the way the statute's currently written, a lot of towns are not comfortable feeling like they have the authorization for online publication. We'd just say that it really ought to be flexible enough to allow the towns to make the choice in what's the most effective way to reach as many people as possible for, I suppose, the lowest cost possible. So I'm happy to answer any questions you have about our publications and the approach that we take with constitutional amendments and rulemaking, and hopefully that clears up some of what the Secretary of State's office does when it comes to publication in newspapers across the state.
So committee, do we have any questions for Chris about that? And Chris, are you going to stay with us so that if, okay.
I will hang on. Thank you.
Thank you. Senator Polina?
This is a detail, but you charge the agency a certain amount of money. So the agency pays you and then you pay the publication?
That's correct. And that averages out to about $2,200 per rule that we publish. And I will just note there are some other states that have done away with that. And I don't know if it was based on expense or based on reach or what it is, but we've been talking to some other states about their rules systems. And Montana's one that we talked to recently, and they said, no, we're able to do this just online at this point. And I think it might have been because of the expense, but I'm not sure.
Actually, $2,000 seems pretty cheap to get to the whole state.
I was thinking the same thing. Wow. Given all those papers, 2,200 plus the staff time it takes to do all that.
I saw Senator Rom Hinsdale had her hand up.
Yeah, I mean, just tied to the language access plan that I want to advance, I actually worry that this is starting to become a civil rights issue, that kind of static information doesn't really easily allow people to translate it into other languages. And so there's a lot of notices you're not getting out to people in a way that's easy for them to translate into other languages.
Is it also on the website, on your website, did you say?
It is. We post a link to the actual text of it, the agency contact for whatever rule is being proposed. And then it's put into, I don't know how big the average rulemaking notice is, but it's usually a summary of the rule is in the actual published newspapers.
Okay, yes, Senator Clarkson.
Well, just to follow up on Keisha's comment, do you have the ability on the Secretary of State's website yet to be able to read things in different languages?
Not that I'm aware of, no.
Because we all hope one day that would be, like when they call you and say, would you like to continue in Spanish or Chinese, or, that you have the option on the Secretary of State's website to be able to actually read it in, you have options.
If that were possible, then communities could pick up different languages from there and publish it.
Or we could drive people to the Secretary of State's website for different language options.
Yeah.
No, I was thinking that what my thought was that if there's a paper that serves a community that has a large population of something speaking a population, that paper could, in addition to sending people to the Secretary of State's website, that particular paper could pick up the language and publish it in their paper if they had that language speaking population. If that made any sense at all.
Yes, that makes sense. A good cut and paste for a community with a language they know is spoken in that community. That's a great idea.
Yeah, Senator Rom Hinsdale.
I mean, the only other thing that occurs to me is the huge drawback of this is you can't correct information very easily. I just think that can't be understated. You put a wrong date, or you spell someone's name wrong, and you can correct it right away digitally. I imagine this has happened before where mistakes have been printed and it's very hard to retract or change in a way that gets people accurate information quickly.
You mean if it's printed?
Yes.
Oh, yeah, I see.
That list is also just concerning. I mean, it just seems like, we'd be saying now, like, oh yeah, put it in the phone book, the list of papers just doesn't feel like it's evolving with a lot of.
I see what you're saying. I didn't mean to imply that they could just put it in print. They could put it in print. They could also put it on their website.
Well,
right. Anyway, yeah, I think that is an issue that we could further pursue. But Senator Polina?
Yeah, and I don't want to belabor this, but part of the issue that we're dealing with here has to do with revenue loss or gain from the papers. That's what we're hearing. So I want to go back to, you charge different papers, different amounts. I mean, I'm just wondering how that worked, how you figure that out.
Sure, I could
Or you
provide
pay
that.
papers, I mean.
They paid it, yeah.
Right, you pay.
I mean,
Yep. We get billed for that, and we pass that through to the agencies. So different papers with different distributions charge different rates. So I could provide the committee with a list of those rates if you're interested.
I'm not particularly interested. I just wanted to know if they charge different rates.
Yep, they do.
I'm sorry.
wait, George-
I'm not sure. Am I able to ask a question on this, or is this for members only?
Well, right now, actually, I'm going to be a little bit, with the committee's indulgence here, be a little bit more informal than we normally are, because this is a kind of we're trying to figure out here where we go. Normally, we would call on you to testify and then, but I'm going to be a little but I want the committee to agree with me about being a little more informal in this discussion. Committee?
It's Friday afternoon, why not?
I had the same thought, Anthony. It's Friday afternoon. Go for it.
I thank you so much. I appreciate it, Senator White. And Chris, it was just a very curious question, if nothing else.
Actually, before, I'm sorry, I don't mean to interrupt, but could you say who you are and who you represent?
Sure. I'm sorry. My name
That's
is Jordan Breckenser. I represent Vermont News and Media. We published the Brattleboro Reformer, Bennington Banner, and
okay.
Journal.
Thanks.
Thank you. Yep. And I appreciate meeting all of you virtually. Chris, I was just curious, do you, and if not, are the website stats available or accessible to see how many people actually come to your state site to seek out these public notices that you put on your site?
Yeah, we could probably get the Google Analytics on that. But just off the top of my head, anecdotally speaking, I don't think a lot of people go there unless they actually know, are actively searching. They know like, oh, ANR is coming out with a rule. I ought to go look it up.
Yeah, that's what I figured. I was curious if you had any idea if it's a huge number or a small number. Thank you.
I don't think it's a big number.
And thanks for allowing the question. Appreciate it.
You're welcome. Does anybody else have any questions of Chris right now? Okay. So Chris, you will be staying with us in case other questions come up.
Sure.
So what I'd like to do is hear from, we have not heard from the two people that are on the list here right now that we have not yet heard from on this issue are Jordan and Gwen. So I'd like to jump to Jordan, if you'd like to give us your thoughts on this and where you're coming from, that would be great.
Certainly, and thank you. And again, I was on last Fridays to listen to you all, and part of my reason for reaching out was purely because if you had any specific questions about the industry or how we process or handle public notices and legals in front of a paywall, behind a paywall, those kind of questions, I'm more than willing to help inform from my perspective. I prepared something relatively small and informal based on, I've worked with the company who owns these papers for a little over 20 years now under several different ownerships. And so I'm relatively familiar with public notices on my end of it. How does a newspaper handle them? How do we treat them? And what does it mean to the newspaper to receive them? So what I have is the current model is a win-win for all parties. Trusted newspapers of record publish these legal notices in compliance with state rules. The readers of the newspapers, either actively seeking out public notices or passively seeking them as they read the paper, are able to engage and stay connected with the happenings in their community and state. In turn, newspapers receive revenue from these notices and fund their operations to provide news coverages within the communities they serve. This works for all parties involved, and it makes sense, and it's why the majority of states continue to treat them as such. The typical newspaper reader is highly engaged in their community. On average, they've lived in the community for 15 years more. They are civically active and concerned about their town. Since the dawn of public notices, these have been linked to community newspapers and are a major fabric of this industry. It's highly unlikely that readers will seek out public notices on online-only platforms at their own free will, except for a few very special interest parties, thus making them less available and less transparent. Additionally, most newspapers who take public notices do publish these on their websites currently. So an online platform already does exist. Now, this is not to say that online-only news organizations should not be able to make the list of approved publications for notices. But I do believe that it requires some requirements and regulations that need to be set forth by the state. This can be beneficial in many areas that do not have a newspaper of record or have minimal circulation to reach the masses. As well, this could set the stage for when more traditional newspapers move to online and digital publishing. There would, however, have to be some state committee to regulate these websites and who can take these notices. They need to ensure that they're local and credible, have a proper archival system and backup to their sites and servers, that they're not easily manipulated or altered. I believe strict requirements would need to be in place to ensure fraudulent or phony websites either local or off the sites of the United States, don't undermine the process. And those requirements are not currently in place. So I believe that's the benefit of a printed newspaper. There is a permanent record, and that record can't be corrupted or erased. As of now, you can look back decades ago to see public notices published, and these are available in both print format for free at libraries, historical societies, as well as newspapers that archive these, as well as digitally and online on multiple sites, such as Newseum, Ancestry.com. I do feel there should be some look into the future, however, as more and more readers shift from printed products to online sources. I believe the ideal situation is the state will mandate that newspapers of record who currently take public notices also have to place these online, in addition to print, and make them accessible to the region they serve. As they do in Massachusetts, I used to work there for many years, the Mass Press Association stood up a website that all newspapers send legals to. So there's one single platform for all notices that the newspapers feed. I think that the Vermont Press Association should consider doing something similar, and obviously with the help of the local news organizations that take public notices currently. In closing, I think the current model is not broken. I think it does require a look into the future as readership continues to grow more digitally. The current model keeps the masses informed on public notices. It reaches and engages an appropriate audience. It maintains the permanent record of notices and is really a necessary fabric of the newspapers who publish them. So that's what I wrote. I thank you for listening to it. And if you had any questions about my testimony or just questions about what public notices mean to newspapers and what the ramifications would be if that were to migrate away, either in the form of revenues from newspapers, or what I really feel is the type of people who engage in public notices. I don't see people, and I think Chris kind of spoke to this in vague terms, but I don't see people searching these out. I see somebody sitting at their counter, the president of a bank, a concerned citizen, somebody who's engaged in the community, and I see them flipping through the paper and they see the public notices. And they see something that they spit their eggs out over and they become engaged with it. And I don't see that person spending their Sunday morning going to an online website, searching out which ones they should be going to try to seek these public notices out. So while I agree there's certainly a place in a room for online only, I think there's a lot of things to be considered. And as somebody said in, I think, a written testimony or last week, my 20-year-old son just stood up a website in his bedroom the other day. And, URLs are easy to obtain. And I would hate to see that fall in the wrong hands where we're not reaching the citizens, the record's not preserved, and it creates a major issue. And my last thing I'll say in closing is, somebody said last week, if it's not broke, why are we trying to fix it? I am curious. I don't say that with any criticism, but I am curious. Are people writing in to the town to say we're having a really hard time finding public notices in traditional newspapers, and if only we could find these online, they'd be better served? And I'm curious if that's something you all are hearing or not. Thank you.
Thank you. Any questions for Jordan? No, I am not hearing that. I am hearing that more and more people are getting their news online, but I really appreciate your kind of differentiating between actively seeking and passively seeking. And I have to tell you that I read a number of things. Well, just so you know, Jordan, I read the Reformer, every word of it, every day.
Better than I am.
No, but I do flip through it and I see things that I would not have sought out. And I see them there and they catch my attention. So I appreciate that term, passively seeking. Senator Colmore, did you have a question or are you just waving your hand?
The latter, Madam Chair.
Okay, thank you. I just did not want to ignore you.
Nope.
Okay, well, we'll continue the conversation here. Gwen, thank you very much. That was helpful and that was well said. Thank you.
Thank you very much. I'll hang around in case any questions come up.
Sure.
Thanks.
Gwen, would you like to join us?
Thank you, committee. Gwen Zaka, Vermont League of Cities and Towns. I did not watch the testimony from the last go around, so I apologize if I'm not hitting all the bases, but I'm here to say that VLCT supports the bill. We have you know, I think others can speak more clearly to, you know, readership and access and all those other things more concretely and perhaps with data. But I think that there's a general desire from our towns and specifically those that are in areas where there are sort of, you know, newspaper deserts, as they call them, to have more means of putting notices out where there's more readership, and this would allow for it. Chris touched upon a point that I think should be noted is that generally VLCT and our legal advice, we tend to be a little bit more conservative. And because there's a lack of case law and other things to say that electronic notifications are the same as general print notifications, we tell our towns that, you know, if you do electronic notifications, they're in addition to print notifications. So it shouldn't be it wouldn't take the place of. So just as a point of clarification, that's generally our legal advice that we give to communities. Whether they follow it is a different story, but that's what we tell them, is to print. And then if you want to do more on top of that, that's up to you. These notifications, you know, they range from things like, zoning, town plans, bylaw changes, charter provision changes, obviously tax sales, right now, town meeting warnings. I mean, these are all things that are going to newspapers to put out to the public for notice. And they serve a really important service. And the whole point of it is to get to readership and to get to the public so they know about it. So the more access, the better. The reason I bring that up is also to point out a provision in the bill that we have a little bit of a concern with. I don't know if we want to get into the level of detail, but I figured I'd point it out
please.
now. Okay, so the new on page 2, where it adds the substantive language, where it's talking about allowing for electronic notifications on starting on line 9, that last sentence of that paragraph reads, however, excuse me, any notice affecting interest of property shall also be published in a conventional newspaper of record. I'm not entirely sure whether this means that there has to be both or one. It's a little confusing, but our position on this is that when you're talking about things like tax sales and you're dealing with property of high value, there is more likelihood of a challenge in court or otherwise to a improper notification if you have 2 of them running simultaneously. So I think the feeling here should be if you choose to make it one way or the other, it should be one way or the other. It either should be print and not allowed to have electronic, or electronic could be the means of doing it. Because if there is any error of one, there's just more opportunity for failure or challenging that notice in a court of law. If the policy decision, and we don't have a position either way. If you want it to be electronic, make it electronic. If they want it to be just print, then just make it print. But this is the one instance where having multiple areas might actually not serve a good purpose. There's just more room for error. Beyond that, I don't think we have much more to add. I think there was a question that was asked about, or I was told there was a question asked about retention of records, or like how towns keep them. And anything that's created in the course of business is considered a public record, so it's retained. So any information is given to a newspaper for print is put into permanent public record. The records, and Chris can speak to this from a VSARA point of view, but they have their record retention schedule. So how long those records are kept is not, the towns don't set that. It's up to the Secretary of State's office and VSARA, but those records are retained. We have to, any person who's making those records, it's public record. So towns have them.
I think when the question was more about the maintenance of the records by the newspaper or the online, not by the towns.
Okay, thank you for that clarification.
Yeah, so I have a couple questions. I'm not sure that I understood your issue about doing it both. Are you saying that if the reformer puts it in the newspaper, in the print part of the paper, they shouldn't also put it on their website?
Sorry. Thank you. Sorry that I didn't explain myself perfectly. So I guess if there's a newspaper that does both and they're getting the same information and it's printed in the same manner, then I think that's fine. I think it was more if there's just a sole electronic, notification that's different from the newspaper, if there's any differences in how the timing of it, if it doesn't meet the letter of the law, there's more opportunity for an attorney representing whomever to challenge it if there's some error in one way, in one manner of notice than the other.
Oh, I see.
Does that
So
make sense?
yeah, if you only have a print portion of your newspaper and you print it, but there is a front porch forum that prints it also, and they might make a mistake or print it differently or something. So it's not the relationship of when they're published by both, but by separate entities.
Right.
Okay, I get that. So I do have one other question, and then I saw Senator Clarkson's hand was up. How do we determine, there's two things here. How do we determine a newspaper desert so that there isn't the availability of print newspapers? Because I think Chester, for example, decided that they were a newspaper desert, and so they do all theirs online. And then how do we determine whether there is an infrastructure desert, so that if it was printed online, people wouldn't have had access to it anyway? I mean, I can think of half of Windham County wouldn't be able to access things probably. So anyway, that's just a question for anybody to answer, because I don't know what the answer is to those. And then I can throw that out, or Senator Clarkson, if you want to throw your question or comment out.
Yeah, I'm sort of with Jordan. I don't know why we can't accomplish both ends, because I would say most of our newspapers are now publishing online, and they are, from what I understand, most of the public notices when they're online are free. So in some ways it's better because you have to buy the paper, but and in many cases you have to buy the digital subscription as well. But in some cases the ads are all free. I mean, the ads are accessible and open. And in the case of the Chester Telegraph, which actually serves 5 towns and is the paper of record for many of those towns, they are a free newspaper, period. So everything is accessible there. I don't know. And then I was just having like channeling Jeanette and thinking, yikes, if this is a town decision for the most part to choose who their paper of record is, why aren't we letting them do that? And I understand the piece of history that is a challenge here, but we're not, even having watched the Vermont Standard destroyed in Irene, nothing is forever. I mean, all those newspapers went. I mean, most of them, they dried out some of them, but I mean, a ton of it went. A ton of that history went. And it's heartbreaking. And so I don't know why we can't manage to satisfy both in this. And I think we're getting there in that section. But anyway, I don't really, it was a clarification on some things and a quandary in the other.
I think one of the issues is not whether there can be both print and online, but can it be online only? And if for example, can a public notice in Brattleboro be printed only on Front Porch Forum or whatever?
That's not a paper. That's not a newspaper.
I know it isn't a newspaper, but it is an online news outlet. Yes, I don't know.
It's like a bulletin board at the
Yeah.
at max. I mean, it's not,
I'm
but it's
saying,
not.
I'm saying it is, but, and I don't remember how we define newspaper here or news outlet, but could that be defined as the Putney news outlet or the Windham County, Southern Windham County news outlet? And I think that was one of the things that Jordan brought up, is who would regulate, who would decide what was an online, what was legitimate, what was not legitimate, who would have oversight over it. So the question here is not, can it be both print and online for the particular news outlet, but can it be only online? And if that's the case, how do we define and regulate the online? I think that's the question.
So to go to the Chester Telegraph, and they would have to come in, Cynthia or Sean would have to come in and testify, but they are the newspaper of record as far as I understand, and they are only online. And I would be curious to hear their answer to this.
Well, we know that they are the newspaper of record there. I guess the question is, who would have oversight over them to make sure that,
but the
yes, Mike.
Thank you, Madam Chair. Couple of things. One, news deserts is a misnomer. I mean, there are newspapers in every single part of the state. So that's one thing. Number two, part of the issue is, and we asked this to be clarified earlier, a couple of years ago, several years ago now. I mean, there is a provision that says a newspaper of record within the county, same county or whatever. And the irony is that Essex County has not had a newspaper based in Essex County for a long, long time. I mean, but they're served by the Caledonia Record, the Newport Express, the Barton Chronicle. I mean, you can get 3 papers up there in Essex County and everything like that. So the fact that somebody has to be, the town has to be with, or the newspaper has to be within the same county as the municipality for the legal and everything like that. I know that is an issue, especially with like the Valley News, because technically they're not even in Vermont. And so can they legally put a legal notice in for the town of Hartford or Woodstock or Windsor or whatever? And I know I was talking with Don Turner, your former legislative colleague, who is a town of Milton municipal manager these days. They've got a big $5.5 million bond vote for a new public works facility. And Milton, their newspaper is no longer printed. It's online only. And he's saying that, he told me today, and I can repeat it, he said, the biggest complaints they get is there is no town newspaper, and that they are in fact using the Islander, which is in Grand Isle County, the adjoining county, to put their legal notices in and to, spread the word about this $5.5 million bond vote and everything like that. And so if you do nothing else, it would be nice if you cleaned up the thing about, it has to be within the same county or the adjoining county or something like that, that a newspaper of record. And every town does, and maybe you don't know, every town during their reorganization meeting, when they elect a chairman, a vice chairman and all that, one of the things they do is declare a newspaper of record for the coming year where people can find the legal notices, warnings and whatever. So that's how the towns do it.
So can I just ask, I saw Kathy had her hand up here, but can I just ask Mike a clarifying question? Is it that the newspaper, the publication of the newspaper has to be in the same county, or the distribution has to be in the same? I mean, guess I'm a little bit if the publication,
We've always taken it to be that the office, where the office was, not necessarily
Okay.
where the printing press was or where something else was, but
that they had an office there.
that the Commons is known to be in Brattleboro, the Brattleboro Reformer is known to be in Brattleboro, the Deerfield Valley News is known to be in your county also.
Okay,
All of those would.
yeah. Okay, I see that. Okay. Kathy, did you have?
You're muted.
Thanks. Thank you, Madam Chairwoman. I just wanted to throw in an observation based on the conversation that we just had about where it came up about Front Porch Forum. I just want to note that the way that the rules are set up now, when a town is publishing these notices, that notice is being published in a newspaper where the revenue is going to fund journalism and community information that's verified and, local reporting. And I just want to point out one of our, I think a major concern of this legislation is that if you set up that system to publish it online only, Front Porch Forum is great. And I love my Front Porch Forum, and it's not moderated. It doesn't support local reporting. It's what everyone has. It's a bulletin board. And I just would be, this is, what I tried to say last week was just to be cautious about an unintended consequence, taking that revenue away from not just local reporting, but, our papers, they have community calendars of events. We have all kinds of different local sports news. We don't in 7 days, but gosh, my kid's on the wrestling team, and I love it when they have their pictures in the paper. Cut them out and put them on the wall. Like those services that bind our communities together are tied up in this too. And I just want to put that in there.
Thank you. I will say that the day after Kathy testified to us last time, I happened to read something in 7 days. I don't get 7 days, but I do just check it online every once in a while. And I happened to read something in there, and I said, you have made a mistake here. You have made, I believe that you made a mistake in your article. And so I never do this, but I wrote to them and said that. And she sent me an email and said, oh, I just read I said, somebody actually reads these?
Yeah.
So anyway.
People are amazed. I always, even when people weren't happy with me, I would always write them back no matter what, and people were always shocked and say, I can't believe you wrote me back after I called you all those names.
Gosh, you sound like legislators.
So I'm aware of the time here, and also the fact that I don't know about the rest of you, but we in Windham County are about to be hit by 12 inches of snow. Yes. I don't know, but if the rest of you are or not.
Better than Boston and New York.
What are they getting?
A lot more. It's really hitting New York and Boston big time.
They can have all they want as long as we get our share.
And
we need
it. Will.
So committee, does anybody have any more questions today about this?
And I bet you read that weather report in the newspaper.
No, I think I heard it on the radio, actually. Chris,
Thank
did
you,
you
Madam
have
Chair. Thank you. Thank you, Madam Chair.
Oh, yes, there also is the radio. We must remember radio.
Love the radio.
So Chris, did you have a question, or were you waving goodbye?
I know you were asking the committee. I'm sorry, I raised my hand.
No, that's fine.
I did just want to follow up with Senator Rom Hinsdale. I can't see her on here. I don't know if she's on anymore. She was asking about language access, and I didn't have a good answer for her. I just wanted to get clarity, and I'll follow up with her directly on whether she was meaning, can our website be translated, or should we be publishing in multiple languages? But I do know that with Google Chrome, it's really good at being able to translate a website. So I was just looking at our APA rules in French and Somali, and it looks really cool. So it works if you have Google Chrome. I know maybe not everyone does, but that's one way to access our rules and get them translated.
That's great to know.
If there's time for one more comment, I would like to offer up one.
Yep, we have time
tidbit.
for one.
Um,
Thank you.
In addition to the other comments that have been made about the value of local newspapers.
Will you just identify yourself?
Oh,
for the
I'm
record?
sorry. Lisa Loomis from the Valley
Yep.
Reporter and the Vermont
Oh.
Press Association.
It doesn't even say your name.
It doesn't say my,
Yes, it does.
Not on
okay.
mine.
Just to the concept of a centralized repository of public notice as opposed to community newspapers and their websites. Centralized repositories of public notices don't receive the added impact and contextualization that happens when trusted local newspapers report on the issues that are the subject of those notices, essentially giving towns twice the bang for their buck. Don't expect some centralized website to cover your planning commission hearing when a developer's proposing 50 or 100 new homes on your town green. Local newspapers fund the reporters who cover those local projects to contextualize and inform the townspeople, and that really works hand in glove with legal notices.
Thank you, Lisa. And we also got your written comments, and we're happy that you got out of wherever you were and could join us.
As am I. Thank you.
So what I'm going to suggest here is that, given the time, I have been trying to schedule ahead here so that everybody knows what we're doing, but also to try to make Gail's life easier so that she doesn't have to scramble at the last minute. And what I'm hoping we might be able to do is this. Let's see, this is 174. I have tentatively put it on the schedule for not next Tuesday, but the next Tuesday, the 8th.
And
Madam Chair.
Yes.
I'll just say Tuesdays are one of the worst days for the media. I think there was some discussion last week. And you said Fridays.
I said Fridays were great because you're done.
Fridays, but Thursdays, Thursdays are the best day of the week usually because most of the weeklies have published on Wednesday. They take a break on Thursday and then they're back at it on Friday. And
I remember,
either Thursday or Friday.
I do remember you saying that, and I apologize. And it's in pencil for that week. It's in pen for next week, but I mean, my schedule is in pen for next week, but it's in pencil for the week of the 8th. So I will change that to Thursday or Friday.
Thank you very much.
Thank you. Thank you for the reminder. Okay. Anything else? Anybody? Thank you all for joining us. I think that, and I know that this was a little less actually, it seems that online, a lot of our committee meetings are a little less formal than they are in the committee rooms. But I think even in the committee room, we would kind of try to do this on a more informal basis because it's important to get people's input to different aspects of what we're doing. So thank you for joining us.
Yeah.
And we'll see you sometime. And hopefully you'll all continue to cover our exciting